Okay. Hello, Mr. Upson, you're up.
May it please the court. Counsel, Keith Upson for Appellant Christian Flores. I'd like to reserve 2 minutes, if I may, Judge.
Sure.
Good morning. Mr. Flores was 19 years old at the time he entered the plea. And as Mr. Chapman correctly noted in his answer brief, Mr. Flores did testify at the plea that he understood he could be sentenced to up to 20 years in prison. And further, he testified that he understood it would be his honor who decides what happens. Does that mean he did understand? I mean, is knowing involuntary always that simple? And you know my thoughts on that well enough from the briefs that I'm not going to repeat any of that this morning. Our point, though, is this, that no rational actor would reject 8 to get 10. That's why we cited not just Parker, which the answer argues unsuccessfully, I would argue, is distinguishable, but rather this court's decision in Griffin, which relied in part on both Rodriguez and Parker. And even then, we rely on it only for the concept that when the court decides to impose a sentence longer than the sentence contemplated, the court has a duty to permit the defendant to withdraw the plea. And that's the gist of our argument and why I wanted to have this conversation with the court this morning. It isn't just that the court knew the state had offered 8 and he had rejected it. It's that the court knew the state had offered 8 and the court was requesting 8 at that very sentencing as well. So, to the trial judge, I understand you have broad discretion, but if you think this is a case that merits 10 or 11.6 or 11.8 or whatever the guidelines sentence would have been, or you think it merits 15 or all 20, that's fine. But knowing the rejected offer had been 8, and while in court the state is still asking for 8, in entertaining an open plea, we continue to maintain the trial judge had really two choices. One, don't take the plea, make him go to trial. Probably not the better of the two, but one of the two. Or 2, if you do accept the plea and then go ahead and impose more than the sentence contemplated, as happened here, when you do get that timely filed motion to withdraw the plea, you got to let the defendant withdraw it. Not letting Mr. Flores withdraw it under these circumstances is the manifest injustice. And not to put Mr. Chapman on the spot here too quickly by wrapping up, but that's why we're asking this court to reverse and remand for the trial court to allow him to withdraw the plea. That may have been a record for me, Judge Northcutt, in principal argument, but I don't see any member of the panel interrupting me to ask questions. So that's what I've got of my 18 minutes, Judge.
You're a better man than I am, Mr. Upson, because in my day, I would have just kept talking. So.
Judge, I know you've seen me do it more than you'd care to count.
I have indeed. Okay. All right. Mr. Chapman, you're up.
Thank you. Good morning. Todd Chapman on behalf of the appellee of the state of Florida. The question before this court is whether or not the trial court abused its discretion in finding that the appellant did not present the manifest injustice necessary to withdraw a plea after sentencing. And the simple answer is that it did not. I would first of all like to note that the appellant has not alleged that there was anything insufficient about the plea colloquy. And during the plea colloquy, I would like to note 3 specific things that appellant testified to. Number 1, he said he knew that it was an open plea. Secondly, he said he knew that he could receive a sentence of up to 20 years. And finally, he noted that he knew it would be his honor that would be sentencing him. Now, during the evidentiary hearing, he testified that trial counsel advised him that he could receive more than the 8 years sentence which the state attorney's office was offering. Now, one other thing I'd like to note, and that is that the sentence he actually received was a downward departure sentence. His minimum guideline sentence was 11.8 years, and he was sentenced to 10 years. In conclusion, Your Honors, this is not a case of manifest injustice, and the trial court certainly did not abuse its discretion in so finding. If there's no questions, I would ask that the judgment and sentence be affirmed. Thank you.
Mr. Upson for rebuttal.
Well, I think another first for me probably ever is that I agree with every factual statement Mr. Chapman just made. I don't know that there's a lot here for me to rebut. And if I were to repeat why, knowing an 8-year offer had been rejected and in the face of a state attorney who is requesting that the court impose 8 years again, it was a manifest injustice for the court to impose a greater sentence and then not permit Mr. Flores to withdraw it. I would just be repeating myself, and I'm confident the panel heard me the first time. So if there are no questions from the panel, I do not keep a journal, but I may buy a diary on the way home to write down the day. I did not take all the time.
I'm writing it down myself, Mr. Upson. I think the two of you used about 7 minutes total, so we like that. Thank you both very much. I don't know if the marshal said before, but in order to leave, click the leave button in the lower, I think it's right-hand corner, at least on my screen of your Zoom screen. And then you'll be gone and we can bring in the next case. Thank you both very much. Travel safely.